That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
I find it surprising that they're alleging that she's in danger.
This isn't just a courtroom dispute, it's a battle of credibility. The defense claims unfair treatment, while the judge pushes back hard. But beneath the legal arguments lies one burning question: who's really being protected here?
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right. Have you seated? 14A District Court of County, Washington, session, the Honorable Judge J.
You may be seated. Court recalls the case of the people versus Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm hearing with and on behalf of Mr. Whitley, standing to my right. Will you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties.
Did you catch that? The judge highlights her own history of fairness, pushing back against accusations of bias. But here's the twist: does a lawyer's poor choice of words risk damaging the client's entire case? What do you think?
Up. Quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it, because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all.
In the end, the judge delays the ruling, balancing fairness with authority. It's a striking reminder that courtroom battles aren't just about laws, they're about trust. What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.
They're bringing him.